my name is Jocelyn, and I'm going to be talking about the Vermont Yankee Nuclear Power Corp case against the Natural Resources Defense Council. A little bit of background on this case. There were two companies that wanted to build and operate nuclear power plants. The Vermont Yankee Nuclear Power Corp and the Consumers Power Company. So the agency with the primary authority to license nuclear power plants was called the Atomic Energy Commission. It has now been changed to the Nuclear Regulatory Commission. And the Natural Resource Defense Council actually objected the granting. The issue was the environmental effects of the process and the disposal of the fuel resulting from the actual operation. The NRDC was then concerned about the environmental impacts of the uranium fuel cycle. There was a case of a nuclear power plant accident that happened in Pennsylvania, and it released a large amount of radiation, so this spooked the public, and it gave force to the anti-nuclear movement. So the idea of nuclear power was very controversial at this time. The NRDC argued that these environmental impacts were significant enough that the commission ought to deny the permits. Because there was so much controversy, it was extremely difficult to get permits to conduct nuclear power plants, which brings us back to the Consumer Power Company. And they had actually applied for construction permits back in 1969, and it underwent an extensive review, hearings, reports, and 7 years later, they were still denied a permit. So the AEC took this into consideration, and they knew how difficult it would be, and in turn instituted rulemaking proceedings, which we will talk about in a second, that would deal with the issue of the environmental effects. So in order to build and conduct, you have to apply for the permits, and every time you apply for the permits, these hearings would take place. So in order to avoid this, they created a rule to avoid wasting people's time and resources, and then they conducted an environmental survey that found that the hazardous effects would be slight. So essentially this would eliminate having to test the environmental impact every time a permit was requested. So this rulemaking procedure complies with the Administrative Procedure Act, which I will go over. But the issue was that it had to do with the rulemaking hearing. So the actual hearings itself, every time a rule is created, it has to get put into this register, and then there has to be an opportunity for a hearing to take place. So even though the rulemaking complied with the Administrative Procedure Act, which we will also go over in a second, there was no cross-examination that would take place at this hearing. So the AEC did not permit parties to engage in cross-examination. Agency officials were allowed to be asked questions, and they answered the questions at the hearing, but there were, and everybody was given an opportunity to speak, but just not cross-examine. So this probably had to do because the issue was so controversial at the time that they didn't want to allow for more controversy to take place. But all the background documents were available to the public. At the end of the hearing, a transcript was made available and allowed for 30 days to respond. The NRDC, however, still brought suit alleging various procedural mishaps, and they were against the AEC's decision. So then this is what brings it to the Circuit Courts of Appeals, and they sided with the NRDC and said that the hearings were committed and unlawfully, and its decision seemed to say that the commission's proceedings were actually inadequate. So this is what led it to the Supreme Court. And the Supreme Court actually, in a unanimous decision, ruled in favor of the Vermont Yankee power plant. They examined the case, and they found that the rulemaking proceedings were followed suit, and they rejected the NRDC's claim that they were inadequate. They also found that the environmental effects were minimal, and again, no, the procedural process was done correctly. So they found their case to be not reliable. And how does this all relate to class? Well, for starters, this has to do with administrative law. And the administrative law is essentially what regulates the procedures agencies use and how we create laws and apply policies to our administrations. It is a way to ensure that practice is rational and fair, and gives the agencies the opportunity to be transparent. The AEC, which was the agency that was allowed to give permits and licenses, is protected under the administrative law, and they were just creating rules and regulations for the Vermont Yankee plant, and it was up to them how they created these policies and how they applied them. And they still went through with the informal hearings, so everything was protected under this administrative law. The next thing is the Administrative Procedure Act, which was created in 1946, and it was to promote rationality and lawfulness in agencies' decision making without imposing overly encumbering procedural requirements. So this gives the agencies the ability to determine to what extent they use this law and the decisions that they make. So because in the Yankee Vermont case, the situation was very controversial, they did decide to go forward with the hearing, it was still, again, informal. And this is because they were allowed to create their own rules. And this allowed the public to voice their opinion and their concerns, but the courts viewed it as the appeal courts viewed this as the APA mandating these minimum procedures, which was not the case. The agency is allowed to add more procedures, so if they wanted to add the cross-examination, they could have, but they chose not to, and the courts can't intervene and require them to do this. This is a very important case because this is the case I would push every case to allow for the informal hearings and just to meet the rules set forth by Congress. Which then brings us to hybrid rulemaking. So this was developed by federal agencies and promoted by Congress, and this was to reduce procedural overkill. So could you imagine if the Vermont Yankee case had to apply for various permits? They would have to go through these hearings all of the time, all these procedural hearings, and there would be no point to the hybrid rulemaking of the informal rulemaking, I'm sorry. So then this brings us to the opinion of the Supreme Court. Judge, and I really don't want to mess up his name, Rehnquist, was the one who issued the opinion, and he said that agencies are free to grant additional procedural rights in the exercise of their discretion, but reviewing courts are generally not free to impose them if the agencies have not chosen to grant them. So you can't require more than the APA has asked for, and as long as they follow procedures, the courts can impose the agency to do more. The judge was concerned that the courts had misread or misapplied the law, which cautions the courts to not impose their own procedures on agencies, and asked them, and so the Supreme Court asked them to stop doing this in further proceedings. Apparently courts had done this in the past and wanted to prevent from happening in the future. And again, this is just the Supreme Court asking lower courts to stop imposing their own decision-making process. And then some more opinions is, in this case, the proceedings were set forth when the decision was not in favor of what the appeal courts wanted. So, essentially, what happened was that the courts only reviewed the agency's choice of procedures after they were conducted and not before they had chosen to structure it in a certain way. So this was only because it was a controversial topic and they didn't like the results of it. The Supreme Court assumed that the appeals court thought that by adding more additional procedures, it would automatically result in more people participating and contributing to the proceeding. So the judge felt that if they were the ones to determine what the best and correct practice is, then the judicial review would be unpredictable. It would probably require formal proceedings on every issue, and it loses the advantages of the informal rulemaking procedures. So essentially the court the judge said that the court cannot act like members of the decision-making unit of the agency, and they can't add procedures that just because they are unhappy with the result that was reached. So that concludes the case. Thank you for listening.